and I'd like to thank you for participating in today's webinar, which is about OSHA's proposed rule on respirable crystalline silica. I'd just like to cover a couple of our ground rules, which many of you are probably already familiar with, and that is that you are in listen-only mode, and consequently we can't hear you, but that you will be able to hear and see the presentation that Adele Abrams is going to present. If you have questions or you have issues that you'd like to raise, please use the dialog box that's on the right-hand side of your screen and send us your questions, and then we will take those questions and pose them to Adele at the time when we do questions and answers. We typically run the presentation so that there is time at the end for questions and answers, but if you have questions along the way, feel free to send those in, because it gives us an opportunity to group them together and try to address like issues at the same time. So with that caveat, let me go ahead and introduce Adele Abrams. Adele Abrams is an attorney, certified mine safety professional, and trained mediator who's president of the law firm of Adele L. Abrams, PC, in Beltsville, Maryland, a 10-attorney firm that represents employers in OSHA, MSHA litigation nationwide. Adele also provides consultations, safety audits, and training services to regulated companies. She is also an adjunct faculty member at the Catholic University of America. She's a member of the Maryland, D.C., Pennsylvania bars, as well as district courts and courts of appeals throughout the country. She's a graduate of the George Washington University's National Law Center and earned her B.S. degree in journalism from the University of Maryland at College Park. She's an active member of the American Society of Safety Engineers, Construction, Mining, and Consulting Practice Specialties. And in 2000, 2008, 2011, and 2012, Adele received Safety Professional of the Year awards from ASSE. She is co-author of the textbooks, The Safety Professional's Handbook, and Construction Safety, Engineering, and Management. She is also chair of the National Safety Council's Committee on Standards, Regulatory, and Legal Affairs. So Adele, thank you very much for agreeing to make this presentation, and the floor is yours.
Well, thank you, Mark, and good afternoon, everybody. I guess good morning to those of you who might be out on the West Coast. And we're going to be going through the OSHA proposed rule for crystalline silica to the extent that we can in the time permitted here. This is obviously a very complicated rule, and I was looking at the proposal again, this morning, getting ready for this, and it's a lot to slog through. It really is. This was in the Federal Register on September 12th, 2013, and we are coming up on the comment deadline, which is next Monday. So the timing of this webinar really couldn't be better. Obviously, IMANA and NISA, and of course the American Chemistry Council, Silica panel, they're all going to be submitting voluminous comments. In fact, Mark, I've been trying to read through all of those comments that you nicely circulated around, and those focus, especially the Chemistry Council panel, in large measure on some of the scientific evidence that OSHA is relying on to support the rule. And I think it's safe to say that when this goes fully into comments, when they start rolling in, when they have the public hearing on it, which is going to be the week of March 18th, and there'll be some post-hearing comments, there's going to be a lot of debate back and forth about the validity of the studies. And, lawyers and scientists are kind of the same in that they can both argue both sides of an argument, I suppose. Certainly there are studies out there that suggest adverse health effects from overexposures to respirable crystalline silica. Certainly there are meta-studies that have been done examining the data in the aggregate that suggest that there may be problems with some of those studies. In some cases, the studies are flawed because of the cohort size being very small. In some cases, there was inadequate screening for other confounding factors primarily smoking when you're looking at the lung cancer studies in particular, and the silicosis studies certainly to some degree. OSHA has put a number of new health effects, or relatively new health effects, on the table here as part of this rulemaking, and the science is certainly less thorough in those areas. And in my view, that indicates a need for further research on this. I mean, I think everybody is well served if we do research the health effects, and we should not be trying to stifle the ability to do research. But I've read a few of the studies over the years that they were relying on in this, and there definitely are some issues. But having said all of that as sort of a preamble to this, I'm not a scientist, nor do I play one on TV. One of the attorneys at my firm is a certified industrial hygienist, and if he were here today, I'd be referring perhaps technical questions about the science to him. But what I want to do really is more of an overview of the issue and the proposed rule, and talk about what the practical world aspects of this rule are going to mean for your operations. So that's really my goal here. First of all, crystalline silica is the chemical compound silicon dioxide, and it does make up a significant amount of the planet's crust. And this is important because, as we'll get into the rule a little bit later on, they're talking about barring job rotation as a method of reducing exposures, because they say, you want to have the fewest people possible exposed to a toxic chemical. And barring job rotation or worker rotation, people use both phrases, can make sense when you're dealing with ethyl methyl death or something, when you're dealing with a substance not found in nature, some chemical compound that is highly hazardous. But what we're talking about here is a substance to which every person on the planet literally is exposed. So, you can't really talk about, eliminating exposure to crystalline silica entirely for any workers. The concern, of course, is exposure to respirable crystalline silica, the particles that are very small, that can be penetrating deep into workers' lungs, and that has been what historically has been linked to the development of silicosis, which, of course, is a potentially fatal lung disease. And this is primarily what OSHA has been looking at as one of the concerns. But at least I anticipate the comments that the National Industrial Sand Association is going to be submitting are going to substantiate the fact that where proper, industrial hygiene practices are utilized, where there's a sound occupational health program in place, that those following the silicosis prevention program that NISA has had in place for quite a while, they have been very successful in eliminating, not just reducing, but really eliminating the incidence of silicosis in their workplaces. And hopefully this is going to carry some weight with OSHA as they start looking at the comments. But they're also looking at crystalline silica as putting workers at risk for lung cancer, for other debilitating respiratory diseases, chronic obstructive pulmonary disease, for example, and even things like kidney disease and autoimmune disorders, although, again, the evidence is really just in an emergent phase on that, and certainly is subject to rebuttal. So what OSHA is doing is looking at a variety of industries where people have potential overexposures to respirable crystalline silica. And of course, mining is one of those industries, but OSHA doesn't regulate mining. MSHA does. But MSHA does have this rule on their dance card as well, and they've been indicating for quite a while now that they are not going to separately do a risk assessment. They're going to be relying on the body of science that OSHA has put together and peer-reviewed for purposes of this rule. And so my prediction on this really is that if OSHA does come out with a rule, MSHA is going to try to get their rule through in parallel with this, with few substantive changes, especially concerning the permissible exposure limit and some of the control mechanisms that are being mandated under this. And it'll probably be put on something of a rocket docket. But besides mining, for the OSHA-regulated sectors, construction, maritime, they are not covering agriculture in this, although obviously agricultural workers do have the potential to be exposed to crystalline silica at fairly high levels. Sandblasting has historically been one of the occupations where you've had some pretty high rates of silicosis developing. Foundries, concrete manufacturing, demolition, even dentistry has been linked with this. And just to kind of look at what's going on in terms of silicosis, there really are three different types of silicosis. There's the chronic or classic silicosis, and that is the one that has a lot of concern here because it has a long latency period. It typically is not going to be diagnosed until after people have had 15, 20 plus years of exposures at relatively low or moderate levels. And so the symptoms of this may not be obvious for a long time, but careful health screening and monitoring can identify potential cases where silicosis could develop down the road if left untreated or if exposures continue. And that's one of the underpinnings of the medical surveillance provisions that OSHA has in the rule, and we'll talk about in more detail. There's accelerated silicosis, and that deals with higher exposures and can occur within roughly 10 to 15 years. And then there's acute silicosis, and this is the one that tends to grab the headlines. And that can occur even in young workers, even after a few months of exposure at very, very high levels. And this basically, causes death. It's a very serious situation. However, the types of activities that IMANA members are typically involved in are at very low risk for development of acute silicosis. Again, it's been mostly the sandblasting industry that has been where these acute cases have arisen. But the reason I bring up all the latency period is that for workers' comp purposes and for tort liability purposes, exposure to crystalline silica at high levels can be a ticking time bomb. And the sampling that you do, the sampling that OSHA does, of course the sampling that MSHA does, this is all going to document either that you have good control methodologies in place or that you do have workers who are being exposed to respirable crystalline silica at higher levels. And that's the information that plaintiffs' attorneys just start salivating over. And, of course, with the additional health effects that OSHA is attributing to silica exposure, that is going to have the potential to bring out another whole crop of lawsuits. And very often, of course, we all know, people move from one industry to another. You could have somebody who worked for a foundry, then they come work at a mine. They might have worked for a mine for a while, then they've gone to work for a construction company, and then they come back and work at a mine again. And so trying to quantify what exposures an affected worker got where, under whose watch, that is really very difficult. The best you can do is be pretty diligent about doing your own health sampling and documenting that you are not having overexposures, and that may be a way to get released from a case sooner rather than later. So taking a look just generally at the OSHA rulemaking, as I said, it came out in the September 12th, 2013 Federal Register, and you probably do want to take a look at this rule at some point. There is a lot to it, as I said, and if you have expert scientific people on your staff, maybe get them to take a look at it. But excuse me, just taking a sip of water there. It's great that IMANA is going to be filing comments. NISA would be filing comments. Many of the other associations, I'm sure National Association of Manufacturers, Chamber of Commerce, a lot of entities on the business side are going to weigh in. But in my view, it's also important if companies can also weigh in on this and be kind of a hallelujah chorus endorsing the comments that your associations are filing, just to help build up the strength of the administrative record, because this is, in all probability, a rulemaking that is going to end up in litigation. I'd be hard-pressed to really think of many rulemakings that MSHA or OSHA have done that have not ended up in court. So, I'm not being a real risk taker here in terms of my predictions. But when they do challenge these things, a lot of importance is put on the weight of evidence and the comments that were submitted to the agency upon which they rely. So the more robust the weight of evidence is in the record that may be suggesting improvements to OSHA's proposed rule or asking for elimination of some of the provisions, that's going to be important. Now, OSHA did put out two separate rules, really. One is for general industry and maritime, and the other one is for construction. And really, right now, OSHA has two different exposure limits, one for general industry, which is the 100 micrograms per cubic meter functional equivalent, and for construction, it's really more like 250 micrograms per cubic meter. And the problem is that there have been wholesale overexposures at the current PEL. And so this is one of the scientific issues I'm just going to kind of speak to here for a second. The fact is that the silicosis cases that OSHA is seeing and that they are using as evidence that a lower permissible exposure limit, or PEL, is needed, doesn't really factor into the situation that people aren't complying with the current PEL. They're not enforcing the 100 microgram per cubic meter level for general industry or the 250 for construction very well. And of course, those of us who deal with mining all the time in MSHA, MSHA shows up whether you need them or not. They're going to try to do health sampling on a regular basis. With OSHA, they don't reach the vast majority of workplaces. And the last statistic I saw on this, I don't want to be one of those lawyers who makes up statistics, but my general recollection was that for OSHA to visit every work site that is under their jurisdiction currently, every employer would get inspected about once every 87 years. So to the extent that there are silicosis cases still being reported, it doesn't mean that the current PEL is ineffective. It's likely reflecting those workplaces where the current PEL is being greatly exceeded by employers. But, OSHA is undeterred. At least right now, it seems like they want to bring the PEL down, and we'll be talking about that. Now, there were lots of extensions requested. There's still extensions that have been requested, but OSHA granted one round and then shut industry down at that point. So the notice of intention to appear at the public hearing was due already back December 12th of 2013. If you did not file that already, you will be not permitted to testify at the upcoming hearings. As I said, the comment deadline on this rule right now is January 27th, which is next Monday. And then March 18th, public hearings are going to begin in Washington, D.C. And there's no real finalized determination of how many days those hearings are going to continue, or whether they're going to have any hearings in other parts of the country. But if you're out in California and you wanted the opportunity to testify, you would have had to sign up for the D.C. hearings at this point, because they haven't given any other options. Now, if enough people testify in March that additional hearings are needed so that other parts of the country can be represented, perhaps they will reopen that, but I'm not seeing any signs of it. And I guess this is a good point to say. This is an important rulemaking for OSHA. It's really been on their dance card for many years, ever since the International Agency for Research on Cancer, IARC, classified crystalline silica as a Group 1 human carcinogen. And they want to get this rule done, and they want to get it done during the current administration, which doesn't leave them a whole heck of a lot of time. Now, it is possible, that there will be another Democratic president to follow President Obama, in which case, if this rulemaking is not concluded, there would still be the opportunity for it to be moving forward. If the Republicans regain the White House and regain, of course, control of OSHA as part of the executive branch, I think, and this rule isn't finalized by then, I think it's probably a dead duck. But we can't really count on that. So we need to try to prepare for this rule as best we can. And as I said, MSHA does have respirable crystalline silica on its regulatory agenda, but there's no real set timeline for that. They're going to wait and see what OSHA does, and then they will move forward with it. So what are the health issues? Well, this, again, bounces around a little bit. NIOSH has estimated 1.7 million workers are overexposed to respirable crystalline silica. They define respirable crystalline silica as particles that are less than 10 micrometers in diameter. OSHA's estimate in the rule was even higher. I believe the number that they're kicking around right now is 2.2 million workers, and then they're saying 1.85 of those are employed in construction. So that's obviously going to be the lion's share of this. But workers can be exposed to this during manufacturing. They can be exposed to it, as I said, in a lot of different general industry areas as well, plus, of course, the maritime sector, which we're really not concerned with here. And what OSHA is saying is that high rates of crystalline silica exposure will lead or could lead to the development of either the acute, accelerated, or chronic silicosis, which I've already discussed, or lung cancer. And, of course, the issue is that a lot of these conditions may be asymptomatic in the early stages. Even lung cancer can be fairly asymptomatic. And, just on a personal note, having nothing to do with silica, I might add, but a good friend of mine went to the doctor, last summer because he had a pain in his neck and was diagnosed with stage 4 lung cancer. So, the first evidence he had of the lung cancer was that it had already metastasized to the bones and manifested in terms of neck pain because his vertebrae were affected. So this is why medical screening can be very important in trying to get early treatment for these types of situations. As mentioned, also, crystalline silica has been classified as a Group 1 human carcinogen by IARC, and as a result, it is now also classified as carcinogen by the National Toxicology Program and also by the American Conference of Governmental Industrial Hygienists, or ACGIH. Now, ACGIH has been pretty aggressive on this, and their threshold limit value for crystalline silica is 25 micrograms per cubic meter. The current OSHA PEL, again for general industry, has been 100 micrograms per cubic meter. That is, by the way, the same functional equivalent as what MSHA can enforce. And then the National Institute for Occupational Safety and Health, NIOSH, has a recommended exposure limit, and that has been out for quite a few years now, and that is 50 micrograms per cubic meter, which is what OSHA is now looking at changing its PEL to. And, on one level, that makes a certain amount of sense. NIOSH was created by Congress as part of the Occupational Safety and Health Act of 1970 with the purpose of advising OSHA in terms of its regulatory activities, as well as for conducting research of its own on existing and emergent safety and health hazards. Now, the ACGIH TLV of 25 micrograms is basically becoming the action level under the OSHA proposed rule. So this is the source. They didn't just kind of pull these numbers out of the air. These are where they are coming from. And as I indicated already, I guess I got ahead of myself here, there is a concern about that long latency period and the impact it's going to have on workers' comp and tort claims. Now, in addition to silicosis and lung cancer, which are the main focuses that OSHA has in this rule, they're also looking at the link between silica exposure and pulmonary tuberculosis. And one of the odd little things in this rule is that when you get to the part about medical screening of workers, they're soliciting comment on whether workers should also be screened for latent tuberculosis at the same time. And, I'm not really sure if this is something individual companies are that interested in weighing in on. It could, of course, increase the cost of the screening, but given that there could be a synergistic effect between pulmonary tuberculosis and silica exposure, this might be something that actually could be beneficial to companies if they discover that an employee has tuberculosis and it can be treated. That may head off silicosis cases down the road. Even things like autoimmune diseases, scleroderma, which is a skin disorder that basically calcifies your skin, and the other autoimmune disorders, lupus, chronic renal disease, and also rheumatoid arthritis, have been suggested to correlate with respirable crystalline silica exposure. And you can imagine, if this rule becomes law and these findings are accepted as fact, the information on this that OSHA has included in its risk assessment and includes in the preamble to the rule, these are things that can be presented to judges and juries, and they can take judicial notice of the Department of Labor's findings. But this is going to blow the doors off of the workers' comp area, because everyone and their cousin who's worked at a quarry or who's worked at a construction site or who has worked at a bagging operation where there's respirable crystalline silica is going to say, hey, my rheumatoid arthritis obviously is due to my silica exposure. And so these cases are going to be magnified. Now, in their risk assessment, OSHA says that nearly 700 fatalities and 1,600 cases of silicosis can be avoided annually if the pills are reduced. And again, just speaking from my view, I think the data is pretty specious about that. We're not having 1,600 new cases of silicosis generally being reported, and OSHA is very quick to say that, well, we think silicosis and silica-related diseases are being underreported. And they probably are to a certain extent. I got to agree with them on that. If somebody dies and they're 75 years old and they die of lung cancer and they smoke 3 packs a day, the death certificate is typically not going to correlate that back to a job that they held 30 years previously. And the employer may not even be around anymore, much less be aware that this individual has passed away from lung cancer or from silicosis. And so, those diseases are not going to be reported to OSHA on a OSHA 300 log or to MSHA on a 7001 form if they're happening 30 years down the road after the company has closed. So, getting a real handle on the incidence rate of silica-related silicosis and lung cancer is hard to get a beat on. But these are addressed in OSHA's risk assessment, and again, if you're into reading the science part of this, you'll want to take a look at it. Typically, OSHA is saying that the overexposures are occurring when silica-containing materials are being cut or grinded or crushed or drilled. And so certainly, IMA and A members do participate in a lot of those activities on silica-containing materials. But on the construction side, you're also having the exposure when you're cutting or drilling concrete or masonry or tile or other types of rock. I do some work in the dimension stone industry, and even outside of the quarry situation, when you get to their fabrication shops where they're cutting slabs of granite, to make tombstones or to make countertops, you can have respirable crystalline silica arising in those situations. On the general industry side, OSHA is looking at the manufacturing of brick and concrete and pottery, and then they're also looking at any operations that use sand products. Fracking is a big one, and I know a lot of IMA members are now starting to get involved in frac sand production, and may in fact even have interests in the fracking of oil and gas wells. People have their fingers in a lot of different pies, but fracking is now being covered in the risk assessment for this rule, and that was one of the reasons I think that it got held up and sent back for a little bit of tinkering after it had originally been sent to OMB, because they wanted to expand the information about the correlation between silicosis, lung cancer, and exposure to respirable crystalline silica during fracking operations. But the main one for general industry is going to be the sandblasting, because that is what creates those acute exposures that I talked about. So again, a lot of the ingredients that they're looking at here we've covered already. Asphalt filler is one that I hadn't mentioned, roofing granules, plastic composites, a lot of construction materials, as well as soil, just when that is disrupted, through drilling or blasting in preparation of a construction site. These are all different ways that people can be exposed. So OSHA's justification for the new permissible exposure limits that they are advocating is getting away from the formula that had been previously used and just, using a hard and fast number. The formulas, as I said right now, equate to 100 micrograms per cubic meter for general industry and 250 for construction and also for maritime. So they're bringing that all together into a single pill of 50 micrograms going forward in this rule. And they indicate that extensive epidemiological evidence exists that lung cancer and silicosis occur at exposure levels below 100 micrograms per cubic meter. But, in terms of OSHA's own sampling data, it's not really there because they're not really even enforcing the current 100 micrograms pill, and that is a big problem. Now, there's other OSHA standards that they have used to enforce relative to crystalline silica. And in part, there's the general duty clause, which cannot be used to enforce a lower pill than what is on the books. They can only use that as a gap filler. But there's also the general industry ventilation standard, 1910.94. The current permissible exposure limit is contained in the air contaminant standard in the Z tables, 1910.1000. They have some specific shipyard maritime sector rules dealing with paint removal and also shipyard air contaminants. And then for construction, they've got the construction air contaminants standard, which is 1926.55, and deals not only with dusts and mists, but also gases, vapors, and fumes. And then finally, ventilation in the construction industry, which is 1926.57. And of course, all of those are in 29 CFR, which is what OSHA falls under. The MSHA standards are in 30 CFR, and they right now incorporate by reference for air contaminants, just so you know, for the metal non-metal sector, the 1973 ACGIH threshold limit values. And for coal, they use the 1972 versions, which don't even have short-term exposure limits. So MSHA stuff is really out of date compared with OSHA's. But having said that, OSHA is focusing on silica as the air contaminant that they want to set a unique level for at this point, and really, have a comprehensive rule just like they do for lead, for arsenic, cadmium, asbestos, benzene, and other bad nasties. Now, historically, in terms of enforcement, as I said, OSHA started looking at this after IR classified crystalline silica as a Group 1 carcinogen, and then in 2008, they kind of relaunched an emphasis program, and this is the one that is currently in effect. It's set forth in CPL 03-00-007. Got James Bond in there for you. And this has an updated list of affected industries. It has a lot of information on potential hazards, information on current research. It gives guidance on how to calculate the permissible exposure limit for respirable crystalline silica in construction. That's really been the focus of it. And it provides guidance for the compliance, safety, and health officers, which is code for inspectors in conducting crystalline silica-related inspections. And what's interesting, I didn't have it in the slide, but I was going back over this yesterday, actually, and they included in there that 2% of all OSHA inspections had to be conducted under the crystalline silica national emphasis program. So that, is a pretty good signal of how serious they are about ramping up enforcement on this. And certainly I'm seeing more silica-related enforcement in the current administration than I had in previous years, just in my litigation practice. Now, the sampling and analytical issues are also a big deal in this rule because they're setting fairly low levels. And again, not a scientist here, but the efficacy of the current sampling methodologies at these lower levels has really not been demonstrated. And OSHA even kind of acknowledges that the laboratories aren't equipped to do the sampling and analysis with the degree of precision necessary for enforcement, for them to be able to carry their burden of proof at trial. And so one of the proposals, one of the portions of the proposal is to allow basically a 2-year ramp-up period for the laboratories to get their houses in order and be able to sample and analyze with precision. I guess some of the laboratories send out their own people to do sampling. Sometimes you're doing your sampling and sending it into them. But they just don't have enough accredited laboratories who could pass muster in this regard. And when you get down, especially to the action level of 25 micrograms, there's going to be inherent unreliability of these samples because you're starting to get near what the background levels are even before you put any industrial processes into play. If you're out on a construction site on a windy day, even if you're not actively breaking any earth or blasting or doing any of that stuff, you're going to have some respirable crystalline silica in the background. And no one, to my knowledge, has really been able to well quantify what those ambient levels are in the average work environment in the absence of respirable silica generating industrial processes. The regulations promulgated currently by OSHA and also by MSHA do require you to monitor for the presence of silica in the workplace. In my experience on the MSHA side, people do a fairly good job of that, especially since a few years ago MSHA launched an emphasis on doing health surveys. They put out a lot of information on that. They explained different ways you could do that, both sampling and also other ways for you to determine whether you have the potential for overexposures. And so they will enforce that more. OSHA hasn't done it a whole lot, frankly, and they don't come in and do that much in the way of industrial hygiene themselves. Although if their safety inspector is in there and he's seeing clouds of dust that he thinks could include respirable crystalline silica, very often they will open a health inspection at that point as well and do sampling. But OSHA samples very few workplaces, so if you want to know what your exposures are, you're really left to your own resources to do that. And of course, you want to be effective in doing it and follow good industrial hygiene protocol. Again, NISA has put out some good information on that, as has IMANA. With MSHA, they will issue a citation based on a single sample taken during a single shift. And that has always been a problematic issue because from an industrial hygiene perspective, a single sample is representative really of nothing because it could be an outlier. You really need to have more robust sampling data to be able to determine if, in fact, a workplace has a problem with overexposures. But that's how MSHA has been doing it for years. They were challenged on that in court. MSHA basically won on that one, and so it goes forward. But there is still going to be the potential for sampling error, especially when you're sampling and enforcing these lower levels in the future, because very few, if any, of the inspectors that OSHA and MSHA have that would be conducting their health sampling are industrial hygienists. On the MSHA side, this is especially true. OSHA has had more COSHOs who are industrial hygienists. They're not always certified industrial hygienists, but they at least try to give, I think, a little bit better training on industrial hygiene to those inspectors who are going to be carrying out health inspections than MSHA does. But still, I know that I've gotten a lot of silica citations kicked over the years, just without having to go to trial, when we've been able to show things like the equipment wasn't properly calibrated, or it wasn't calibrated at the right altitude where the sampling was actually going to be conducted. They've got the wrong pump flow rates going on. They're hanging samplers in the wrong spot. They're not hanging it in the breathing zone, for example. I've had a few MSHA cases recently where my clients reported that the inspector would hang the pump in the morning and never come back to check on the workers at all until the end of the shift. And that violates MSHA's own protocols for industrial hygiene silica sampling. Sometimes they'll take the pumps off while they're still running and lay them down on the table. Well, if you do that, that's going to invalidate the sample. And I even had a case a couple of years ago where it turned out that the worker who was being sampled for silica in the middle of the workday took his break for lunch and sat down on the ground to eat a sandwich and took his pump off and lay it down, sucking dirt, basically, right on the ground next to him. And so, of course, when you get that kind of information, it's relatively easy to get these samples or the citations that are associated with the samples vacated. But, just a tip from my perspective is, while this rulemaking is going on, both with OSHA and MSHA, if you are in a workplace that they show up and they want to sample, take very, very good field notes yourself so that you can challenge their findings. Because otherwise this stuff goes on the public website showing that you've had an overexposure to crystalline silica, and if you get sued 20 years from now, that's going to create a historical record that can be used against you in tort litigation. If you have the ability, you should be trying to do side-by-side samples, because then if the MSHA or OSHA sample is off the Richter scale and your sample is within the permissible limits, that again is something that can be used defensively. And the goal is not to have any of these silica citations that either agency might issue stick on your record. But there certainly is the sampling error due to the inexperience of the inspectors or some of the lab analysis problems. And again, if they reduce this down to the 25 microgram permissible exposure limit, or this 50 micrograms permissible exposure limit, or the 25 micrograms action level, which is what's in the proposal, we're going to have a lot more overexposure records coming out. I mean, they've even indicated, even though they're claiming this is a feasible standard, they've said that 2 out of the 10 covered industry sectors aren't going to be able to comply with these lower levels. So hopefully there'll be more evidence put into the record on that. So what are we looking at? Well, let me give you a little bit of background on this rule as well. The first glance that we got at this was in 2002, when a draft proposal came out and was put through the SBREFA process, which is the Small Business Regulatory Enforcement Fairness Act. And they put several alternatives out there for consideration. One of them was to keep the Pell as is at 100 micrograms for an 8-hour time-weighted average. They had also suggested dropping it to 75 micrograms, and then the third and most draconian was to drop it down to 50 micrograms, and of course that's the one they ended up going with. The proposed, it included employee training, hygiene facilities, respirator use, but only to be used after you have exhausted engineering and work practices that are technologically and economically feasible. And then you would have to maintain and use these engineering and work practice controls to keep exposures below the Pell unless they were not feasible. And, I can tell you I have raised economic and technical feasibility in a number of cases over the years. The judges are not real keen on buying that. And, what OSHA considers technologically feasible, they're saying this is a technology forcing standard. So that's one of the big issues here. They're acknowledging that the technology may not be feasible just now, but they're banking on the fact that by the time this rule becomes final and enforceable, that technology will have caught up with it. And in terms of economic feasibility, you have to show that it would work a major hardship on your company. And going out on the limb here, most of the companies that belong to IMANA are going to be hard-pressed to demonstrate economic infeasibility. Whereas if you have a small construction company, a subcontractor, 5 guys in a truck, the controls that might be necessary there, they might be able to make a showing of economic infeasibility. But again, it's an affirmative defense that the employer has the burden of proving, and there have been very, very few decisions over the years where that defense has ever been accepted. So fast forward from 2002 all the way up to the current 2013 proposed rule, and they did differ from what was put in the SBREFA in that they went with the 50 microgram level, but they set the limit, but they set this action level of 25 micrograms. And of course, in 2002, when the draft proposal was circulated, that was before the ACGIH had lowered its threshold limit value down to 25. So, you know, that number wouldn't have been being floated around as feasible to measure at that point, but now it is. And the proposed rule includes, again, provisions for measuring worker exposure to silica, for limiting access to areas where workers could be exposed above the permissible exposure limit. So you're going to have access restricted areas or regulated areas under this, under certain circumstances. Requirements for dust controls, requirements for the use of respiratory protection as needed, medical exams for those workers who are highly exposed, worker training, and record keeping. And we'll go through the various aspects of this. For exposure monitoring, they're looking at a couple of options. One is requiring you to do sampling on a set schedule, or a fixed schedule as they call it. And then there's also the performance option, which would allow you to assess as necessary to adequately characterize worker exposures. And you would not have to do exposure monitoring in the construction side if the employer implements dust controls that are listed in Table 1 of the proposed rule. And they've got about a dozen specific construction tasks. Then they explain in there what the engineering controls are that should be utilized, or the administrative controls, and they indicate what respiratory protection would be appropriate. What is kind of a wild card in this whole thing is they're acknowledging that for some of these construction practices, even if you implement everything that OSHA has listed in Table 1, you may still be above the permissible exposure limit. And they've been silent as to whether they would still be able to cite you for an overexposure under those circumstances. So that's something they're seeking comment on. And, you know, I would assume that everybody in the construction sector is going to say, no, if we've done all of this stuff, we should be deemed compliant with the rule. Kind of like for those of you on the mining side, which there's probably a lot of people on the call, with noise, back when they used to issue P codes for the noise standard, if you had implemented all feasible engineering and administrative controls and furnished personal protective equipment, they would not come back and recite you for still having workers exposed above the 90 decibel level. They've done away with P codes since they put out the new noise standard, obviously, and OSHA's never really had those. But they do acknowledge that things like tuck pointing, you're not going to be able to get below the Pell, even by following their steps. But they said, again, technology forcing rule, so shouldn't be a problem. I think there's some folks who are going to find that to be a problem, though. Moving right along here on dust controls, you've got a variety of things that you can use: water sprays, enclosures, ventilation systems, vacuum dust systems. But the rule as written prohibits dry sweeping, and they've asked for comments on that. You know, are there situations where dry sweeping should be permitted? For example, a construction site where there might be limited access to water, or where using water could result in problems from an environmental perspective. So that's something to weigh in on. They also are looking at barring the use of compressed air for cleaning surfaces and for cleaning clothing. And the work that IMANA and NIOSH have been doing in terms of the the cleaning of workers' clothes, certainly that's something that should be brought to the attention of OSHA in the rulemaking record. Now, as far as respiratory protection, they specifically prohibit the use of employee rotation or job rotation as a method of reducing silica exposures. And that's something, again, that I think a lot of people are going to comment on. I know I do a lot of work with the ready-mix concrete industry, and obviously they have to clean out those drums from the concrete trucks. That can create some high respirable silica exposures, and typically people do wear respiratory protection going in there. But a lot of the companies I work with, their standard procedure had always been to rotate workers in and out of that position so that nobody would be doing more than like an hour and a half, 2 hours at a time on any particular day. And that would be a way of ensuring that all workers were kept below the permissible exposure limit. So, if this rule passes as proposed, there are a lot of companies that follow a similar approach that are going to have to revamp their work practices. In addition, you have to offer medical exams to workers who do tasks that require respirators for more than 30 days a year. And so this is going to be something that the burden will be on the employer to be tracking how many days each individual employee is wearing respiratory protection, and then making sure that they're offering the medical exams to workers. They're not going to require workers to have the medical exams, but you're going to have to make them available. You can only use the respirators where you can't reduce exposures below the PEL through dust or work practice controls, or while you're in the process of installing dust controls, then you would be permitted to use respirators. The current administration at OSHA, very strong on occupational health issues compared with some that have come before this, and they really don't like the use of personal protective equipment. In their view, workers should not be burdened by having to wear respiratory protection. They shouldn't have to be burdened by wearing hearing protection. The burden, in fact, should be on the employer, in OSHA's view, to make modifications to the workplace so that personal protective equipment is not necessary. And so I think that's, flowing through this rule as well. For medical surveillance, this gets tricky as well. You have to do medical surveillance on workers who are exposed above the permissible exposure limit for 30 days or more a year. You'd have to have an initial exam followed by periodic exams every 3 years. And, that's probably not a bad idea. If you are doing medical surveillance, in my view, that's probably an appropriate interval. It certainly is consistent with what is in the ASTM Silica standards that I'll talk about here in a couple of minutes. And the exam has to include taking a medical and work history, physical exam, chest x-ray by an ILO B reader, and a pulmonary function test. And then, as I mentioned already, they're seeking comment on whether a latent tuberculosis test should be required to be included on the worker's initial exam. And be interesting to see how all of the comments come out on that. So let's take a look at some of these data that OSHA has included in the rule. And the next few charts, I will say, have been borrowed from OSHA. These are not charts I put together, so don't blame me if you disagree with the data in them. But they wanted to see, what's the silica exposure range currently, and they're looking for numbers of affected employees. But they're claiming that 54% of construction workers are exposed below the action level of 25 micrograms per cubic meter. Another 11% are exposed in that interim range of 25 to 50. 12% roughly would be in the 50 to 100 microgram. And then basically, 11% are between 100 and 250, and another almost 12% are over 250, which is the current exposure limit for construction. Now, for general industry, they're claiming that, and shipyards, 38% are below the action level, 18% would be in the interim level, and then basically everything else on that chart would be considered an overexposure. So, doing, kind of some quick math on that, we're looking at about 45% of workers currently being sampled would be out of compliance, or not workers, but workplaces would be out of compliance. So that's a pretty big deal. I'm frankly surprised that they have as many people in construction at under 25 micrograms as they do. I would love to look at that data. I haven't looked at it yet, but I'm sure that will be discussed quite a bit because this ties in definitely with the feasibility issue. And if OSHA truly is able to demonstrate data saying that more than half of construction companies are already below the action level, it makes it more likely that that action level will be sustained in the final rule. The employer obligations, trying to pull this together for you here, if you're below the action level, then you only have to do for exposure assessment and initial assessment if workers are reasonably expected to be exposed below the action level, or if you're following Table 1 if you are in construction. Now, if you are above the action level but below the revised Pell, you'd have to do the initial assessment, but then you'd also have to do periodic monitoring every 6 months, which is that fixed schedule, or the performance option if they decide to make that an option in the final rule, or follow Table 1 for construction. And then if you're above the Pell, if you're above 50 micrograms, you'd have to do the periodic monitoring after the initial assessment every 3 months, or you'd have those performance option or the Table 1 options. And the requirement for regulated areas and access control, there are none as long as you are under the Pell. But if you are above the revised Pell at 50 micrograms, you have to establish and implement regulated areas or have a written access control plan. And they've sought comment on whether a competent person would be required to establish the regulated area or to be the person writing and implementing the written access control plan. And they've also sought comment on whether the competent person should have to have specialized training for this purpose. And again, I think we're going to be seeing comments all over the board on this, ranging from having to be a CSP or a CIH in order to carry out those activities, to requiring them to go through an OSHA 30-hour course or an OSHA 10-hour course, or just plain vanilla, somebody that just by virtue of generalized training, perhaps under the Hazard Communication Standard, would be found to be eligible to do that. And that's something, again, they're inviting comment on. Now, in terms of methods of compliance, again, if you are below the Pell, no changes need to be made to the workplace. But if you are above the permissible exposure limit, you're going to have to use the feasible engineering and work practice controls, or for the construction side, take the steps that are outlined in Table 1 for the particular tasks that you're performing. And similarly, for respiratory protection, there's no requirement for it if you are below the Pell, but if you have exposures above the Pell, then you are going to have to provide respiratory protection to workers or follow the recommendations that are set forth in Table 1. And another thing is, in terms of some of this, they're looking at workers. It's triggered by the worker being there 30 days from their initial assignment. And I think there's a real potential here, especially on the construction side, for this to encourage people to use contingent workers or temporary workers, day laborers, whatever you want to call them, so to ensure that no worker stays on their payroll for more than 29 days. This is kind of like the backlash that you've been seeing and reading about on the Affordable Care Act, where they're saying, to get people down below the requisite number of employees that trigger it, or the number of work hours that would trigger the provision of benefits, they're scaling back on that. I think this could be part of the law of unintended consequences as well. For medical surveillance, this is really the thing I was just talking about, where the 30 days is the trigger. You don't have to do medical surveillance if people are below the Pell, but you have to do an initial exam within 30 days of the initial assignment, and then periodic exams every 3 years thereafter. Hazard communication, OSHA's new global harmonization hazard communication rule is out. We're all aware of that. All of the training for the GHS rule was to have been completed by December 1st, 2013. So if you haven't done it yet, this is just a reminder that you need to do that training if you're under OSHA, and you need to document it. And MSHA has said that they will consider compliance with the OSHA GHS rule to also be compliant with MSHA's with MSHA's hazard communication standard. But they've added and training to workers on the potential health hazards of crystalline silica and the appropriate means of protecting oneself through the hazard communication standard. But if you look at the 87 questions that OSHA has posed in its proposed rule, they ask, should there be supplemental training on the unique issues associated with crystalline silica above and beyond the training that is required under the hazard communication standard? And so people will be weighing in on that, and if you have strong feelings one way or another on yet another thing that you have to document, you probably want to let them know about it. For record keeping, you have to maintain exposure assessment records for workers who are, for all workers basically. And then for workers who are exposed above the permissible exposure limit, you also need to keep the medical records. And if you look at the ASTM silica standards, which OSHA seems to be channeling quite a bit in this rule, what they are talking about in terms of keeping records is either 40 years or the employee's period of employment plus 20 years, whichever is longer. So if you don't already have one, you probably want to invest in a good scanner so you can keep these records electronically, because that's a lot of records and a long time that you're going to have to keep them. Now, I've been talking about the ASTM standards here on and off, and industry generally recognize the need for there to be some comprehensive standards to control and address the hazards of crystalline silica exposure. And so there have been two standards that were developed. The ASTM E1132, which is for general industry. OSHA references the 06 version in the rule, but there's actually an E1132 2013 edition now. It was not changed substantially or anything. And then for construction, there's the ASTM E2625, which is a 2009 standard, and that will be coming up for review and perhaps revision over the next couple of years within ASTM. And these standards do not include an occupational exposure limit. Yeah, I actually sit on the committee, the ASTM E34 committee that developed these standards. And this was something we kicked around quite a bit, and ultimately there was no unanimity or any kind of consensus to be found on putting a number in there. And knowing that MSHA and OSHA had these rulemakings going on, we felt that it would be dating the standard if we picked a number and put it in there, and then the rule came out and it went in a different direction. But what it does include are provisions for exposure measurement, for the use of dust controls, for respiratory protection, medical surveillance, and also for worker training. And if you want to get ahead of the curve on what OSHA is looking to require, I'd say get hold of these standards, because that spells it out for you in a pretty user-friendly manner and can help you get your program on board. Now, for those of you who already are part of the silicosis reduction programs that NISA has, or have adopted the occupational health programs, that have been put together, you're probably ahead of the curve on this stuff anyway. But if you happen to be, somebody who's new to this area, you might want to take a look at those for guidance. And this is, why ASTM standards are important. Under the Technology Transfer Act of 1995, and as implemented by OMB Circular A119, if a federal agency is going to embark on a rulemaking, they have to consider consensus standards that are out there and are on point. And they are encouraged to adopt those standards. And if they choose to go in a different direction from an existing national or international consensus standard, they actually have to explain in the preamble to the final rule why they are doing so. So this couple of hundred-page proposed OSHA Silica standard is replete with references to these ASTM standards, and they also, are seeking input on whether the standard should be incorporated by reference as a whole or whether portions of it should. But, being familiar with the ASTM standards, to a fair extent, and then reading OSHA's proposed rule, it's almost like they've cut and pasted portions of it already. So before doing the general industry standard, they are required to look at E1132. Before doing the construction standard, they have to consider E2625, which dealt with both construction and demolition. And again, both of these are referenced in the proposed rule standards, and both of those are, I believe, able to be purchased from ASTM directly, and I get no commission on that, so this is not an advertisement. But what's in these? Well, as I said, there are no occupational exposure limits set. They don't specify any particular sampling or analytical method, although they do list in the beginning of the rule a variety of testing and sampling and analytical methods that are used. Primarily, these are the OSHA and NIOSH methods. They establish a hierarchy of engineering controls, administrative controls, respiratory protection, and also work practices. In the construction standard, they actually have tables, and they don't have just the one table like OSHA does. There's actually 5 or 6 tables that list a number of different construction tasks. And OSHA has really, shall we say, R&D, ripped off and duplicated that approach in the construction part of this standard in that famous Table 1. But they're looking at masonry cutting, they're looking at concrete mixing, they're looking at cutting concrete, and also drilling activities in those tables. The rule requires, or it doesn't require anything. This consensus standards use should. They don't use shall. Shall is mandatory, should is not. And of course, the ASTM standards were not developed with the idea of them becoming enforceable standards, although, having said that, that's always in the back of your mind when you were working on developing consensus standards because of OMB Circular A119. But there's qualitative and quantitative risk assessment that is called for. A lot of the information here is actually pretty good in terms of figuring out what an employer could rely on if they're trying to use the performance option, and if they're trying to also gauge initially what their exposures might be. So you're looking at the light duration, the proximity of the airborne dust to workers, the nature of the process, the location of workers, and also your historical sampling data. And for construction especially, you've got so many short-term work sites that, as a practical matter, you're not going to have historical data for that same work project. I mean, complex construction projects might last a year or two, or in the case of the Boston Big Dig, I suppose, like a lifetime. But most projects, you're in and out of there in less than 6 months. And so you're not going to be having the same circumstances for doing repeat sampling. And that's why I think for construction, the ability to rely on historical data involving the same equipment, the same type of tasks, is probably a good approach. ASTM, again, encourages employers to do sampling and maintain records of the exposures that they're having on site, to use supplied air respirators or ventilated enclosures, and to establish exposure control plans. And again, OSHA seems to be borrowing some of that. And then the non-mandatory appendix to the ASTM standard also suggests more engineering work practice and administrative controls. and also lists what permissible exposure limits are for crystalline silica in the U.S. and also some states which have particular things, or for some of the foreign countries, many of which do have exposure limits that are comparable to what OSHA is proposing in this standard. So again, to recap the impact of this proposed rule, 2.2 million workers. The majority of those are going to be in the construction sector. OSHA says 1.3 million, so about roughly half are going to be in small establishments, and 500,000 of those are in very small establishments. Those really are the five guys in the truck type of thing. For the establishments that are going to be covered by this rule, they say 500,000 establishments. Again, vast majority, 477,000 in construction, 57,000 in general industry and maritime, and of those, again, a lot of them are very small companies. So you can do the math there. Now, what about MSHA? Well, right now, you have to do hazard communication training on the potential hazards of silica exposure, including if they're going to be using it, the GHS system. MSHA will do sampling at the mines and enforce based on a single sample, and they expect you to be doing dust, gas, mist, and fume surveys as frequently as necessary. What is as frequently as necessary? Well, that's kind of in the eye of the beholder, I suppose. But for sure, if you've had changes in equipment, processes, you've reconfigured your operation, you can't at that point rely on your historical samples to demonstrate compliance anymore. You would need to do some resampling at that point to determine if your controls are adequately protecting your workers. And the person doing the survey has to be knowledgeable or experienced on how to measure the particular contaminant. MSHA has done some noise and dust sampling workshops. They've done some of those through the National Stone, Sand, and Gravel Association. And I'm not trying to pitch another association, but I know that some IMANA members also belong to NSSGA. I've actually been through that workshop myself, as have a couple of the other attorneys at my firm, because we want to be able to be competent to defend some of these silica and noise citations. And I found it to be a very good course, but the kicker is if you go through that, then MSHA will let you borrow sampling equipment from them as well. And those courses are open to non-NSSGA members, I believe, as well as members. And, depending upon where MSHA goes with this rule, that may be something to look at down the road. But the course is taught by Rocky McKinney, who is an MSHA employee, and the last one of these they actually did down at the Mine Academy. So they do have industrial hygiene courses as well that they offer without any affiliation to any associations at the Mine Academy. It's unclear whether going through those courses would make you eligible to borrow MSHA's equipment. But it's certainly, getting your ticket punched on one of those courses eliminates the issue about whether you are competent or knowledgeable enough to measure the contaminant, and so can be useful if you're trying to show that your sample is correct and the overexposure that MSHA has collected is not correct. Now, if you do have a sample that results in an overexposure, MSHA expects that you're going to take action, but they don't have a very prescriptive list of actions you have to take, which is why, of course, if they're going to mimic what OSHA is doing in this rule, there are going to be some significant consequences at mine sites just because of the pervasive presence of MSHA inspectors and their ability to cite you for failing to comply with any portion of this. With OSHA, unless you, frankly, tick off one of your employees or you kill somebody or you fall under one of their national emphasis program enforcement sweeps, you're probably never going to see them. It doesn't mean you don't have to comply with this. You will have to comply with this when it's the final rule. It just means that you're not likely to get audited on it with the frequency that you would for a comparable regulation that's adopted by the Mine Safety and Health Administration. So final thing I just wanted to touch on briefly here, and I do mean briefly, is all of this is going to have an impact on silica litigation. And as we all know, silica-related claims allow parties who think that they've been injured as a result of exposure to silica dust to seek reparations, to seek damages. If it's your own employee, you may be insulated because it could be brought under workers' comp insurance. But a lot of us have contractors who work at mines and who work at facilities, and you don't have that workers' comp shield there. And this is why having your own good data is going to be very helpful, because when the plaintiff's attorneys bring these cases into court, they're generally not being able to show any kind of exposure data to quantify exposures. They simply say, the plaintiff worked for Abrams Construction, and Abrams Construction does drilling and blasting of silica-containing materials, and therefore our client was exposed to crystalline silica while he worked for Abrams Construction, and now he's got lung cancer. And that's kind of how they present these cases. MSHA and OSHA data will document if you have had overexposures, and so that can and will be used against you in a court of law, which is why, as I said up front, you want to challenge it if you get an MSHA citation that you think is bogus, or an OSHA citation that you think was not accurately sampled. And a lot of the focus in the litigation over the recent years has been on the inadequacy of warnings. Now, you've had to have silica-related warnings on products ever since the OSHA standard came out in 1986 for chemical industry and 89 for general industry. The latency period, though, does mean that at least for some of your older workers, exposures could predate the training and the warnings that they received under the Hazard Communication Standard. And although the sophisticated user defense is something that has been successfully raised in a lot of these cases, there still are some courts that have rejected this. And there was a real sweep of silica tort actions back about 8 years ago, and a lot of those cases were found to be fraudulent. That was part of that multi-district litigation, and the judge in those consolidated cases threw out the vast majority of them, and in fact, lawyers got disbarred. There were even some congressional hearings on this, and that kind of put a stake in the heart of silica claims becoming the next asbestos, which is, for a while, I was getting materials from the American Trial Lawyers Association and the American Association for Justice, they call themselves now, and they had turnkey kits for lawyers on how to bring this kind of stuff, but it is slacked off now. It doesn't mean, though, that you don't have exposure, and so documenting your own lack of overexposures historically, in my view, really is key to defending against frivolous lawsuits that might be brought related to crystalline silica. So you're doing yourself, a world of good if you, first of all, control your exposures, and second of all, sample to document that you have done so. So the bottom line, the accuracy of sampling and analysis is going to continue to be very critical in determining what your actual exposures are, and the 50 micrograms level is difficult to sample to with precision. I've kicked this issue around with some industrial hygienists I know, and they've said even with the current methods, with adjusting for the error factor, it's only going to be accurate down to, I've heard, anywhere from 55 micrograms to 61 micrograms, which certainly means that trying to measure accurately down to 25 micrograms, the action level, is wishful thinking at this point. But who knows, maybe OSHA will drive the technology, and there will be new and improved sampling methods out there by the time this rule becomes final, if in fact it ever becomes final. But in the meantime, manufacturers of silica-containing products, which is a lot of you on this presentation, have to be diligent about updating your warnings, continuing to monitor the state of the science that's out there, recommending the appropriate use of personal protective equipment for those downstream users of your products. As an employer, you have to be diligent about training your own workers in safe practices. You want to provide personal protective equipment where it's appropriate. You want to try to start off with engineering controls to reduce exposures at the source to the extent that you can do so feasibly, both technically and economically. And, again, my recommendation is also to act now, if you haven't already done so, to adopt an occupational health program or a silicosis reduction program or silicosis prevention program, I should say. But these standards are coming. The ASTM consensus standards already can be used by courts to set a level of care and to notice what best practices are that you could or should be using. And these eventually may be incorporated into the OSHA and the MSHA standards. So if you have thoughts on that, you probably want to add that to your comments. And I'm going to go ahead and wrap it up there. I welcome any questions there might be to the extent I can answer them. And if not, I can always research it and get back to you. But thank you very much.
Okay, thank you, Adele. We have several questions here, and I'm just going to roll through them. The first question is, Adele, did you file a notice of intent to testify?
I did not, as an individual, for various reasons. I represent a lot of companies that would be affected by this. I also do some work for the American Society of Safety Engineers, and I did not want to come out and express my own position on this and then have it perhaps imputed to any of the entities that I represent. So although I am actively going to be following this and I'm going to attend the public hearings as an observer, I was not going to testify.
Okay. Next question
I haven't decided yet. I could still submit some written comments, but probably not.
The next question is, what is asphalt filler?
Asphalt filler is an asphaltic material that contains silica that is just used as part of a construction material. I believe it has to do with roofing operations. I do some work with roofing companies, and I know they use asphaltic material to fill in the gaps between some of the shingles that they put up on the roof. And so I think that's what it's referring to.
Okay. And Adele, will you give your opinion on the importance of dual sampling? I had a chuckle there because it actually reads the impotence of dual sampling, but it's importance, I'm sure.
Well, I can make a bad joke and say that's a hard issue.
Oh, there you go.
You walked me into that one, Mark. As I said during this, there's so many bad, and by bad I don't mean overexposures. I just mean badly done samples by OSHA and MSHA. That if you do not do comparative sampling, having a pump on the other lapel, you're really without recourse other than pointing to your historical data to try to get a citation vacated. But if you're doing side-by-side sampling during an OSHA or an MSHA inspection, and their sample comes out at, let's say, 125 micrograms per cubic meter, and yours comes in at 78, they have the burden of proof in court. And so you can use that side-by-side contemporaneous sample to defeat it. And very often, I've never myself had to take one of these all the way to trial, because when I show my IH data that my client has done through their side-by-side sampling to the solicitor who's representing OSHA or MSHA in these cases, and I also show them after having gotten their analytical documentation and discovery that they're using the wrong pump flow rate, or I get an affidavit from one of the employees who was being sampled saying that OSHA or MSHA never came back to check on them for 8 hours, it's very easy to discredit an OSHA or an MSHA overexposure because they just screw it up so many times. But if you're not, on it yourself doing the side-by-side sampling, you have really nothing to rebut that sample with.
Okay, next question is, what is the earliest possible date that the rule could become effective?
Well, I have to look at my crystal ball on that. Once they finish the public hearings, then they will have to have a period available for post-hearing comments, and typically that might be another 60 to 90 days. And after that, they have to review the record. But if they kind of know where they're going already, they could turn that around pretty quickly. We could see a final rule, I would say, before the end of the Obama administration. And this very well could be one of these midnight rules, just like we saw in the Clinton administration with the MSHA diesel particulate standard. I mean, they may wait till the very last moment to put it out. They may hold up to see, and this would be really more my prediction, I guess, see who wins the next presidential election. And then they have that window between November and January to know either we have to rush this rule out, even if it has a lot of warts, or we can take our time because we're going to have a like-minded president succeeding President Obama, and really that gives us another 4 years to work on it. So the presidential election is going to be very key, I think, in how quickly they push this rule through. And of course, remember, OSHA did that with the ergonomic standard as well. And then the first thing President Bush did, when he took over, and Congress, was use the Congressional Review Act to kick the rule to the curb. So that could be an outcome as well. There's a lot of things to put in play. In terms of the enforcement of this rule, they're going to have to allow, though, some lead time, because they're already talking about giving laboratories 2 years to develop the accreditation and the precision to be able to accurately analyze the samples down to these levels. And so it would be difficult for them to be writing citations when they're acknowledging that the laboratories can't do that yet.
Yeah, I don't have the Federal Register notice in front of me, but I seem to recall that the effective date is 180 days after the rule is published in the Federal Register.
Right, but they really haven't reconciled giving the laboratories 2 more years.
No, that is an outstanding issue right now.
Yeah, so, certainly for anybody who's on this call who's planning to submit comments, that's probably something to bring up because certainly employers should be given the same lead time as laboratories.
Okay, we're running short on time, so let me just get through these last few questions. Do you recommend ambient air monitoring, and here they're emphasizing winter or summer as baseline work, especially in the mining industry as well as plant facilities to establish a baseline?
Well, when I hear you say ambient monitoring, I'm hearing that as area samples, and if that's what it means, never a bad idea because it can tell you which areas you may have to look at generally in terms of having higher silica exposures and where you could predict that workers in turn might be exposed at higher levels. But for enforcement purposes, they aren't enforcing area samples, they're only enforcing personal samples. But you're absolutely right, whoever made or posed the question, that there can be some variations in the efficacy of sampling depending upon environmental factors, including temperature, including humidity, and even altitude. And that's what I was talking about, in terms of the calibration of equipment. If you do it at sea level and then you're using that equipment to sample in Denver, you're going to have some variations there. But it would give you at least a sense of whether you're having higher exposures using the same processes and the same equipment in certain months, as opposed to just doing one sample and going, this must be good for the entire year.
The near final question is the record keeping requirement really employment plus 20? They note that it's typically 30 years.
Yeah, my understanding is that they were looking at what ASTM is doing there, and I think I misspoke. I think I said 40 years or employment plus 20. I think it's 30 years or employment plus 20. But, that is consistent with what they're doing in a lot of other health standards at OSHA. And of course, all those records have to be made available to employees as well. I didn't mention that. And if it's consistent with the other OSHA standards, the union reps or employees reps would have the opportunity to look at that data as well.
Well, the next question I have is not a question, but it's a comment, and I'll second it. It says, "Great job, Adele." And I just wanted to let everyone on the call know that we'll be sending out a copy of the PDF of the slides that were used by Adele, and it'll also be recorded, so if you want to hear it again at some later date, you can do that. And so, Adele, thank you for the excellent job that you did, And thank you all for participating in this webinar, and I wish you good luck and good fortune with the OSHA crystalline silica rulemaking.
Thank you.
All right, goodbye.
Bye-bye.